Today we'll be looking at rape in the Malaysian context, things like consent, non-consent, and statutory rape. In spite of heavy punishment, including the death sentence in some countries, rape still remains a serious problem in many parts of the world. Proving a case of rape in a court of law is a very challenging task. There are many reasons attributed to this situation. Rape being a criminal offence, a proof beyond reasonable doubt is necessary before establishing guilt. In many instances, the offence is committed in the absence of any eyewitnesses. Owing to various reasons, even other corroborative evidences are either lacking or absent. As a result, in many rape trials, the court is in a dilemma. The court is often caught between the testimony of the alleged victim and the suspect. Generally, in any criminal trial, independent corroboration may be necessary before establishing guilt. In many other countries, however, the evidence ordinance pertaining to rape laws has been amended to accommodate uncorroborated testimony of the victim. However, in practice, the task becomes difficult for the court in the absence of independent corroboration. Now, this is where the doctor may play the important role of providing necessary corroborative scientific evidence to prove a case of rape. The doctor's opinion is expected to be independent and scientific, and therefore it not only corroborates the crime, but may also help an innocent person who has been wrongly implicated. Now, this video today will not be addressing any medical considerations. In many countries, particularly in the West, there are full-time forensic physicians who are specially skilled to undertake the examination of sexual abused victims. Their ability to conduct scientific examination and to provide objective opinion may help the court to arrive at a firm decision. Specifically looking at Malaysia, however, even though we won't be going into this in detail today, I do want to say, according to my research, I found that clinical forensic medicine is not included in, for example, the undergraduate curriculum, and postgraduate courses are only available in forensic psychology. So there are no trained full-time forensic physicians to undertake forensic clinical examinations. The respective clinicians in larger institutions and non-specialist medical offices in smaller hospitals, they actually undertake clinical forensic examinations. The majority of doctors who undertake such examinations have no previous training in such procedures. Therefore, it is not surprising that in many instances, the quality of clinical forensic examinations show many shortcomings. So what exactly is rape in Malaysia? Rape is dealt under Section 375 of the Malaysian Penal Code. According to this section, a man is said to commit rape who has sexual intercourse with a woman under the following circumstances: A, against her will; B, without her consent; C, with her consent, when her consent has been obtained by putting her in fear of death or hurt to herself or any other person, or obtained under a misconception of fact, and the man knows or has reason to believe that the consent was given in consequence of such misconception. D, with her consent, when the man knows that he is not her husband, and her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married, or to whom she would consent. E, with her consent, when at the time of giving such consent, she is unable to understand the nature and consequences of that to which she gives consent. And F, with or without her consent, when she is under 16 years of age, which is known as statutory rape. The word rape is derived from the Latin repere, which means to snatch. It is generally believed that there should be some evidence of violence present on the victim before accepting that rape had taken place. The evidence of violence is expected to arise from the rapist who uses physical force on the victim or by the victim's struggle. Now, this evidence of physical violence to justify that there was no will on the part of the woman for sexual intercourse was derived from early 19th century English common law. This belief has led the court to look for the presence of some form of physical violence on the victim to corroborate the allegation of rape. Now, the subsection in the Penal Code, which says against her will, is generally established by the presence of physical violence. The Malaysian law on rape still retains that subsection, against her will, in its legal definition under Section 375 of the Penal Code. This subsection, against her will, usually places the burden on the rape victim to show evidence of physical violence that could be considered as an act against her will. In many jurisdictions, consent for sexual intercourse becomes the sole issue in deciding whether rape has been committed. Consent, when given, should be free, voluntary, and informed. A person who gives consent should understand the exact purpose for which the consent is given. She should be of consenting age and in a mental state and of mental development to understand the implications. There should not be any force, duress, or fraud while obtaining consent. The responsibility also lies with the person who seeks consent to be satisfied that the woman is consenting freely after having understood the implications. The English law on rape is very clear on this issue. It says that at a trial for a rape offence, the jury has to consider whether the man believed that the woman was consenting to sexual intercourse. The presence or absence of reasonable grounds for such a belief is a matter to which the jury is to have regard, in conjunction with any other relevant matters, and considering whether he so believed. In many countries, the rape laws have been amended whereby the defendant has to prove that there was consent for sexual intercourse. In Malaysia, the position still remains unchanged, and the prosecution has to establish that the woman did not consent. For a girl, the consenting age for sexual intercourse is 16 years. Therefore, sexual intercourse with or without consent with a girl who is under the age of 16 years is considered as statutory rape. In Malaysia, a person under the age of 18 years is considered a child. Therefore, a person under the age of 18 generally cannot give consent for medical treatment. However, a girl under the age of 18 but over the age of 16 can give valid consent for sexual intercourse. A similar situation prevails in other countries as well. In Malaysia, prior to the Penal Code Amendment Bill of 1986, the age of consent for sexual intercourse was 14 years. At the University Malaya Medical Center, the pediatric department handles rape victims who are under the age of 18 years, whereas victims over the age of 18 years are handled by the gynecology department. However, the gynecologist conducts the genital examination in all cases. And then you've got the Child Protection Committee and the Intervention of Sexual Assault and Molestation Team, who are two organizations that oversee the management of child and adult sexual assault victims. Going on to marital rape now. Traditionally, it is considered that it is not legally possible for a husband to rape his wife unless the wife is below the stipulated legal age and in Malaysia at 13 years old. It was believed that consent to marriage is also consent to sexual intercourse, and as long as the marriage is in existence, this right to intercourse cannot be revoked. Now, women's groups have argued that by giving such immunity, the marriage license can indeed be called a license to rape. It is significant to note that marital rape is not recognized in Malaysian law. Being an Islamic country, regard may have been given to the Quran, which is the holy book for the Muslims, which says that it is a wife's duty to submit to the husband's sexual needs, and therefore there is no such thing as marital rape. On the other hand, the Quran also emphasizes that men should at all times respect women and value their freedom. The only exception in the Malaysian Penal Code is when the wife is under the age of 13 years and during the iddah period, which is the period when the wife has to wait 3 months before divorce is final, just to determine if she is pregnant. In a 1991 case, Regina and the Crown, 1993 was actually cited, the English court held that there was no longer a rule of law that a wife was deemed to have consented irrevocably to sexual intercourse with the husband. Therefore, a husband could be convicted of rape or attempted rape of his wife where she had withdrawn consent to sexual intercourse. In Malaysia, if we're looking at what intercourse is, in Malaysia, vaginal penetration by the penis, however slight, is sufficient to constitute sexual intercourse for the offence of rape. Even the tip of the penis between the labia has been accepted as intercourse in law. If penetration cannot be satisfactorily proved, the defendant may be convicted of attempted rape, and if intent is not proved, he may be convicted of indecent assault. It is not necessary to prove the completion of sexual intercourse by orgasm or ejaculation of semen. In most countries, including Malaysia, the rape laws are related to unlawful sexual intercourse between a man and a woman. Now, let's compare this to French law. Okay, the French law, however, is a striking exception to that general rule. French law defines rape as any act of sexual penetration of any nature committed on another person by violence, constraint, threat, or surprise. According to French law, rape does not concern only penile penetration of the vagina or an offence involving only a man and a woman. Then we see the 1997 anti-rape law of the Philippines, which is also quite similar. It included insertion of the penis into another person's mouth or anal orifice, or the insertion of any instrument or object into the genital or anal orifice of another person without consent, and it deemed it as rape. At present, many countries have replaced the crime of rape and other traditional sex crimes with a series of gender-neutral and graded offences with appropriate punishments. In most countries, the term sexual intercourse has been replaced by sexual penetration. The term sexual penetration is defined to include sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusions involving any part of a person's body or of any object into the genital or anal opening of any other person's body.